A recent ruling from the nation's high court allows Phoenix to enforce a ban on camping and sleeping in public. This coming just a few weeks after the Department of Justice slammed the Phoenix Police Department for its treatment of unsheltered people, claiming officers violated their civil rights.
That element of the Department of Justice report, as it relates to Phoenix and the way they have arrested homeless persons in Phoenix, basically gets wiped out by the Supreme Court opinion.
The DOJ claimed it was a violation of the 8th Amendment to arrest people for merely sleeping in public when they had nowhere else to go, citing cruel and unusual punishment. Constitutional law expert Robert McWhirter says that statute was established in 2019 in the case Martin v. Boise. The key argument in that case was that criminalizing sleeping in public targeted someone for their status as being homeless. Now, the nation's high court overturning that, meaning arresting someone for sleeping in public does not criminalize their status, but rather their conduct. However, McWhirter says there are still other claims in the DOJ's report about the way Phoenix police officers allegedly treat homeless people that remain unconstitutional.
Arresting them without probable cause, stealing their property, taking their property.
The city of Phoenix responding to the Supreme Court decision, saying in part, quote, "The city will continue to lead with services and will not criminalize homelessness while we evaluate our programs based on the court's ruling."
Phoenix police and the city did make some policy changes before that DOJ report, including creating an Office of Homeless Solutions and adding new shelter beds. The Phoenix City Council also unanimously passed a new law leading to fines or even jail time for anyone camping within 500 feet of parks, shelters, schools, and daycares. That law goes into effect in September. Derek?
All right.